Hello everyone, I am Dr. Anupma Goel, Professor of Law at National Law University, Delhi. In this week, earlier you have already discussed with Dr. Manoj judicial appointments and accountability, and now we are going to discuss the same topic on the basis of National Judicial Appointments Commission and what happened to that act and the constitutional amendment which related judicial appointments and also judicial accountability. Currently, one of the important debates in India is concerning judicial appointments and judicial accountability. All the three organs, legislature, executive and judiciary, are trying hard to make them happen within the values of Indian Constitution. Any legislation which is for judicial appointments or judicial accountability has to be within the basic structure of Indian Constitution, like we have judicial review, independence of judiciary, judicial activism for the protection of fundamental rights, etc. In this paper, we are going to discuss what is presently the constitutional status of judicial appointments, how the judges are going to be removed from the office and what are the basis for those removals, if any. Along with that, what is now the Supreme Court's viewpoint on these issues of judicial appointments and judicial accountability. The role of a judge is very crucial for the maintenance of rule of law, human rights and ultimately to maintain and upgrade democracy. His or her appointment is also to be seen that the process is within the values of the Constitution of India. Process has to be such which gives us impartial and independent judges, and there is not unreasonable interference by the executive while we are appointing judges, especially to the higher judiciary in India. As per the constitutional provisions which we have already discussed, firstly I will touch briefly those provisions and the important case law, and then we will come to the National Judicial Appointments Commission Act of 2014 and how and what happened to that act and the commission constituted under that act. Firstly, under Article 124 and 217, judges of Supreme Court and High Courts are appointed respectively. Under Article 124 Clause 1, this has been mentioned that every judge of Supreme Court shall be appointed by President by warrant under his hand and seal after the consultation is done with the Chief Justice of India and other judges of the Supreme Court as deemed necessary by the President, and that judge would hold office until he attains the age of 65 years. Under Article 217 Clause 1, High Court judges are appointed. It says, every judge of the High Court shall be appointed by the President by warrant under his seal and hand after consultation with Chief Justice of India, the Governor of the state, and where the appointment is of a judge other than Chief Justice of that High Court, the consultation with Chief Justice of that state's High Court has to be there, and that judge will hold office until he attains the age of 62 years. These are the bare provisions which are there with regard to the appointment of judges to the High Courts and Supreme Court in India. How these constitutional provisions have been interpreted from time to time and how we required that procedure needs some change, we are going to see and analyze that journey now onwards. In the initial years after the constitution is passed, there was a time when law minister used to select and appoint judges to high courts and supreme courts in consultation with Chief Justice of India and judiciary at large. In S.P. Gupta versus Union of India in 1982, it was held that where a judge of Supreme Court is to be appointed, the Chief Justice of India is required to be consulted. But again, it is not the concurrence, but only consultation, and the central government is not bound to act in accordance with the opinion of Chief Justice of India. The ultimate power of appointment rests with the central government, and that is in accord with the constitutional practice prevailing in all democratic countries. As this judgment was giving strict and literal interpretation to the provisions relating to appointment of judges in the higher judiciary, it was criticized by academicians, jurists as well as lawyers. Unreasonable interference by the executive or absolute intervention by the executive regarding appointment of judges sometimes create problems for independence of judiciary. This judgment was overruled ultimately in 1993 by another Constitution Bench judgment of 9 judges, which is Supreme Court Advocates on Record versus Union of India, where they overruled the judgment given in S.P. Gupta versus Union of India and evolved a collegium system for the appointment of judges to the higher judiciary, because the court said in cases of appointment of judges, it is the primary role of judiciary, it is the topic which belongs to judicial family, where executive cannot be given absolute discretion or power. So therefore, they introduced a system of collegium wherein Chief Justice of India would consult 2 senior-most judges, and after having those consultations, the opinion regarding who is going to be referred to the government, those names would be sent, and on that basis government is only having power whether to approve of it or reject any or all of those names. So in a way, the primacy now lies with the Chief Justice of India along with 2 judges, senior most judges of Supreme Court, with regard to appointment of judges to the higher judiciary. In this judgment, the Supreme Court also said that constitution makers were also of the view that primacy has to be ensured to judiciary while appointment of judges are to be made, as it is very clear from the constitutional provisions itself that consultation with Chief Justice of India or the Chief Justice of High Court is mandatory. The court also said that when we are having this plurality of judges giving opinion, and on the basis of which Chief Justice of India is recommending the names for nominee judges, this will check against any kind of arbitrariness, and procedure would be a fairer procedure as compared to executive individually or judges individually deciding regarding the appointment of judges. After this case in 1999, to give a kind of elaborate extension and clarification with regard to 1993 judgment, there was a presidential reference. In this case, in re-presidential reference of 1999, the Supreme Court said that plurality of opinions by 4 senior most Supreme Court judges is must to formulate the opinion of Chief Justice of India regarding the appointment of judges in the higher judiciary. They clarified that there is a requirement of Chief Justice of India to consult 4 senior most judges when he is giving recommendations with regard to the names of Supreme Court judges and also for the transfers to be made with regard to Chief Justice of any state's High Court or with regard to the appointment of any judge of the High Court. With regard to the appointment of High Court judge, there can be Chief Justice of India having consultations with 2 senior most judges of the Supreme Court. Thereby, in all, the consultation and the primacy of judiciary is paramount as per the constitutional provisions also whenever there are appointments to be made in higher judiciary. The role of executive as well as Supreme Court of India along with Chief Justice of India is mandatory. But Chief Justice of India cannot give his sole opinion without having consultations with other judges. That will create some problems.